Big decision tonight in Maine, the latest front in the ballot battle raging as the presidential campaign is just about to kick off into high gear. Maine's Secretary of State is now removing the former president from the state's primary ballot based on the 14th Amendment's insurrectionist ban. Maine is now the second state to disqualify Trump after Colorado kicked him off its ballot over his role in the riot at the United States Capitol on January 6th. And joining me now is A. Scott Bolden, a litigation attorney, and Harry Littman, former U.S. attorney. Scott, to you first. Now we've got two states, Colorado and Maine. They've essentially said they want to throw Trump off the ballot, although it sounds like he'll remain there for a little while, pending appeals, of course. The counter argument some are making, and you heard it here on this show in the last hour, is this is unfair to voters to not be able to have these decisions being made in a transparent way, in a uniform way, state by state. Do you think that should weigh in at all for the Supreme Court?
No, not at this point in time. The law enables this opportunity to keep individuals off the ballot. It empowers voters because the Constitution says that if under Title III or under Section 3, if you engage in insurrection or if you aid and abet an insurrection, then you disqualify yourself from being put on the ballot, whether you're the president or any other state or federal official. So I don't think that should be in the mix. And these two opinions, because the law allows it, then they did fact-finding. They made determinations of law. And quite frankly, I think the Maine decision, and I don't know how Harry feels about this, but the Maine decision is even going to be harder to overturn if it gets to the state Supreme Court or the federal Supreme Court, because this was done under what we call the Administrative Procedure Act for Maine. And the standard of review is whether her decision was arbitrary and capricious. That's a much more difficult standard to overcome. And both the Colorado and Maine decisions were rooted in state rights, which we know conservative justices like to hang their hat on, and it was based on strict constructionist theory, looking at the plain language of the Constitution and ruling against Donald Trump. It's going to be interesting to see if they want to overturn these state decisions, because I think the way these decisions have been written, it's going to be difficult for them to do so.
Scott,
the
go
Supreme
ahead.
Court will have no choice in this because every state controls its elections, both whether it's federal office or state office. So unfortunately, Harry, I think they're going to have to weigh in because they'll have no choice because every state controls their own election process. They could easily say, listen, this is a state issue. We're going to punt it back to the states, and it's up to the states to decide whether to put him on the ballot or not. Or they could go deeper and say, as an insurrectionist, they could redefine insurrection, what an insurrection is. They could argue that it's too vague, and they could send it back to the federal legislature to define what that constitutional provision means. But Article 3 courts interpret the Constitution and federal and legislation and state legislation all the time. It's their duty to do so. So regardless of how complicated this is, and no matter what Chief Judge Roberts, while he doesn't want to politicize the court, they're going to be in smack dab in the middle of this political process because of Donald Trump's bad conduct on January 6th. I don't think they have much choice. They're going to have to delve into it to make it right and to make sense of all these different decisions.
Scott, the Trump team, they wanted this Maine Secretary of State removed from the case over a series of tweets. These are comments that she's made over the months and years that are critical of Trump, critical of January 6th. Do you think that that is a problem for the Maine case?
I don't think it is. There may be an appearance issue there, but in an administrative procedure process, you've got to make decisions based on the facts, whether there's been substantial evidence submitted, and that she wrote an opinion based on the evidence before her. It's a succinct opinion. There's not a whole lot of her political considerations or her political thoughts in it. It sticks to the facts. It sticks to the evidence. And remember, the Trump side on this, the Trump defense lawyers certainly didn't submit substantial evidence to rebut it. They attacked it on procedural grounds and tried to keep this evidence out. But the January 6th report came in. Her decisions will be reviewed at the higher court level. But here again, unless they find that her decision was arbitrary and capricious, which is kind of consistent with kind of what the Trump's arguments are about her being too prejudiced to render a fair and independent decision, If they don't find it was arbitrary and capricious, then technically and legitimately, this decision should stand.